Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today's Doug Austin, and is dedicated to the late, great Judge David Waxy. It's called Important eDiscovery Case Law Decisions for March of 2023. Our faculty experts are Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel. This webinar will be recorded and available for replay at your convenience as every month's webinars. Kaylee Walstad, EDRM Chief Strategy Officer, is here with us today. What do we have for resources today, Kaylee?
Well, my favorite things are up here. Keep up with your eDiscovery daily news and case law by subscribing to eDiscovery Today, which is how I start every day. But I also cannot miss Tom O'Connor's spicy Techno Gumbo blog. Ooh, that's hard for me to say. Be sure if you're not subscribed to that, you subscribe and check it out. And then you can learn more about the Honorable Judge Peck and how you can engage with him by clicking on the link below. And up next on EDRM's webinar channel tomorrow, ChatGPT, should eDiscovery lawyers be nervous? And that is sponsored by Merlin Tech. And then the spring 2023 eDiscovery Business Confidence Survey is open, and your valuable insights are needed. And it literally takes 3 to 4 minutes to take it. And we would really appreciate you sharing some of your time. And back to you, Mary.
Thanks, Kaylee. And our listeners, you can download a certificate of attendance from the Counsel after the webinar for use in your continuing ed requirements. And our faculty, Doug Austin. Doug Austin is the founder and editor of our EDRM trusted partner, eDiscovery Today, and an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. And at Legal Week this year, Doug had a personal best of 5 posts in a day. And Tom O'Connor, hailing from the great city of New Orleans. For over 3 decades, he's stewarded the Gulf Coast Legal Technology Center and has a wonderful YouTube channel for long-form interviews. He's a sought-out consultant on some of the largest cases, and he wrote the book, an ebook on eDiscovery for the rest of us. It's available at his great blog site, as Kaylee had mentioned, the technogumbo.blog. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions. And later, writing opinions on things like boilerplate objections, 502D orders, and technology-assisted review. EDRM is grateful to all 3 gentlemen for serving on the EDRM Global Advisory Council. And Doug, I heard rumors we have some cases to discuss today.
We do indeed, Mary. Thanks and welcome, everybody. Glad to be here after BrightTalk threw me a password curveball. I've never been good at hitting the curveball, so got here just in time, thankfully.
We're glad too, Doug.
Indeed. So, and honestly, our cases have so much going on this month. I wish I had bigger slides because there's a lot to cover in them. And they include a request for production of all calendar items and text messages, a request for sanctions for supplemental production due to a vendor's deduplication error, request for production of all search term results without review, sampling of purportedly privileged documents for in-camera review, an adverse inference sanctions case for spoliation of text messages, a lot of spoliation, and sanctions for violation of a protective order. And just a reminder, we do welcome questions, and we'll try to get to as many as we can, and we'll send a copy of the slides out after the presentation, so look for that too, and you can check out the cases on your own. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers, like eDiscovery case law rulings, march on. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 28,700 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Here's a case that was suggested by Judge Peck, perhaps partly so they can show us all how to pronounce that long D word in the case name again. In this multi-district litigation, the plaintiffs sought an order compelling production of all calendar items for approximately 45 custodians and text messages after only a linear review from defendants BASF, WCA, and Huntsman over a 5-year period. These calendars and text messages had already been subject to search term review, and all 3 defendants had already completed their production. However, the plaintiffs contended that these document productions yielded by those defendants' search term review were inadequate, and that production of text messages after linear review and full custodial calendars was necessary. The defendants contended that their search term generated productions were the result of agreements between the parties that producing all remaining calendar entries and text messages, irrespective of relevance and in contravention of the parties' stipulated ESI protocol, was beyond the permissible scope of discovery. Despite agreeing to search terms previously, the plaintiffs reversed their position and concerning defendants' use of search terms here. Pennsylvania District Judge Scott Hardy noted that while it is true that the use of search terms is imperfect and may exclude some relevant documents, not using search terms when reviewing a voluminous universe of documents also risks expending time and resources to cull through and produce large amounts of irrelevant documents. Consequently, search term methodologies are routinely used, particularly in large and complex commercial and antitrust cases, as an acceptable, if not preferred, approach. He also noted in denying the request, importantly here, the parties previously agreed upon the stipulated ESI protocol, which does not exclude calendar entries or text messages, and which requires that they discuss and attempt to reach an agreement on search methodologies with the goal of limiting the scope of document collection, review for production, and facilitating production in accordance with the deadline set by the court, with the goal of identifying responsive documents. So, Tom, did the plaintiffs make a mistake in not negotiating a different approach for the calendar items and text messages and the ESI protocol?
No, I don't think so. I think they could have done this if they had carried through a little bit better. As the judge pointed out, the process that they had agreed on, the protocol was that the defendants were going to apply some search terms, even including calendar entries and text messages, and then send those along, and they both, as the judge said, contemplated the plaintiffs would make follow-up requests based upon their review of those productions. But as he further said, and I'm quoting now, it's plainly evident the parties were not wholly in agreement as to the actual search terms to be utilized, despite agreeing generally to the use of search terms, end quote. So I think the protocol was good, but they didn't follow through by saying, okay, we're going to use search terms, we're going to do this, you're going to review it, come back and ask us for more if you think so. And they never agreed on the search terms. So I think the whole thing was doomed. And then finally, the judge also pointed out the plaintiffs didn't show on the record what the actual deficiencies they were claiming were for the search terms. As he said, they didn't define if the searches or the search methodologies were either, quote, unreasonable or inadequate. So, end quote. So he had nothing to hang his hat on. So I think the protocol could have worked if they had followed through on the process.
Sure. Well, that makes sense. So Judge Peck, Judge Hardy cited the ESI protocol, which didn't treat calendar items and text messages differently from other ESI. So when, if ever, would you as a judge disregard the ESI protocol in a ruling like this?
First, I want to note, Doug, that you skipped pronouncing the name of the case.
Yes.
It's
I love that for you because you're so good at it.
there you go. Diisocyanates. And at the recent online webinar for the Sedona TAR case law primer, I think it was John Pappas suggested that every time someone pronounces the name of the case correctly, everyone should take a drink. So there you go. But now to answer your question, I mean, litigation to a certain extent is a contract. And if the parties enter into any sort of stipulation, an ESI protocol or anything else, they're likely to be held to it by most judges, absent some serious deficiency. So if you have an early ESI protocol and you don't talk about calendars, or you talk about calendars and search terms, you're basically stuck. And as the judge here said, perhaps if there had been a showing of a severe deficiency, or, through some other method, the requesting party was able to show that the producing party was missing things in the calendar entries, that might cause me or any other judge to deviate from the protocol. But we've seen this previously when we covered months ago the Valsartan case or other TAR cases where there was an ESI protocol and then a party wanted to vary from that to use TAR. You may well be held to what you agreed to.
Yeah, which I think is why you really need to think about what you're agreeing to up front, right?
Exactly.
Indeed. All right. So one of the things interesting to me, Mary, is that calendar items often contain minimal data, so they're often difficult to search. So how could a request for calendar items have been presented that was both proportional and comprehensive, or is that even possible?
Oh, it's got to be possible, because calendars, my goodness, they're the things you can hang a timeline on. So yeah, they are sparse with data. They're different than emails, so they're searched differently. But in this particular opinion, we have a good suggestion or mandate. Such follow-up discovery requests should be non-cumulative, specifically targeted, and not generalized, and be informed by the documents and other information produced to plaintiffs thus far. So if we look at that, the metadata that's available in calendar items, you've got time, and we oftentimes have a date range limitation. So you've got that to use as one vector. And then you have custodians or, the people involved. And you can ask either for one person's calendar for a particular date range, or perhaps whenever 2, 3, or 4 have met in a particular time period or in a particular location. And many times there are agendas or other information inside calendar items. So I wouldn't say it's quite a loss. They are different than email, and it takes a different kind of processing, but I think they're very, very worth going after.
Yeah. Oh, absolutely. Question from the audience: were the search terms agreed to at the start of discovery at FRCP or state equivalent meet and confer 16F and associated schedule? In state court filings, I find the omission of such 16F schedule and agreement to search terms are not completed or incomplete. Federal courts seem to have more rigor. Well, certainly it seems here that search terms were agreed to as part of the ESI protocol, which was part of the meet and confer. Any comments from any of you on that particular question and comment from the audience?
My guess is the search terms were not presented to the court and so ordered by the court, although I could, I'm guessing there.
Mm-hmm.
Usually, what the court gets is the parameters of what type of discovery is happening when, etc., or it gets a protocol or stipulation that, when presented by the parties without disagreement, is not going to be carefully analyzed by the court.
Yeah.
Yep.
I mean, the judge stated, sorry, Doug, the judge stated that quote, the parties were not wholly in agreement as to the actual search terms, end quote, which would seem to indicate that the part they didn't agree on was the part that had the search terms.
Right. Speaking of search terms, one more question from the audience. Are there any opinions on the practice of running search terms on text messages? The language used is often very different in text as opposed to email. Man, we could spend a whole webinar on that.
I was going to say that's a webinar in itself, huh?
Right. But yeah, absolutely. Excellent point. Any quick thoughts before we move on?
My experience is a ton is going to depend on what type of text messages, what the program is, what the phone system is.
Sure.
There's a lot of variables there.
Yeah.
So tips, get an expert.
A lot of emojis too.
Emojis. Yep.
Yeah. I mean, I think the two tips that come to mind for me is how you group the text messages together. And then I think I found that it's a little more iterative because sometimes you're finding the abbreviations or what have you as you go. So that's one of the things that obviously you get a lot more with text messages that maybe you don't get with emails. So some great questions, but we want to get to our cases. So we're going to move on to the next one. Which is a complex construction case that involved a lot of document production, and numerous disputes, leading to several discovery conferences with the court. This particular dispute occurred after the court granted defendant's motion to amend the scheduling order and continued the discovery deadline to September 16th of last year. That was after the defendant discovered a deduplication error by its eDiscovery vendor, which caused an underdisclosure of a significant number of documents. The defendant notified the plaintiff of the error 3 days later, and after the court had held an informal discovery conference, they entered an order requiring the rolling production of the newly discovered documents to be completed by August 1st, and the defendant produced over 79,000 additional documents, all within the deadline. As a result of the defendant's supplemental production, the plaintiff redeposed 5 fact witnesses, but still sought to recover the fees and costs it incurred to prepare for and take the 5 depositions and the fees to prepare for and argue this motion for sanctions. Virginia Magistrate Judge Robert Ballou stated, "I agree with Fleur that the 80,000 documents mistakenly withheld due to BAE's vendor error and produced between June and August 2022 were not timely disclosed." But he also stated, applying the Southern States 5-factor test to determine the appropriate sanction under Rule 37C, I do not find additional sanctions warranted. While the document production resulting from the vendor error was a surprise to Fleur, BAE immediately notified Fleur of the error, cured any surprise by producing the documents within the deadline set by the court, and allowed Fleur to redepose necessary witnesses. Fleur received the documents within the discovery period, and the additional evidence did not disrupt any motions deadlines or the trial date. Fleur does not argue and cannot that the late production impacted its ability to fully prosecute its case at trial. As a result, Judge Ballou declined to award sanctions against the defendant, stating, among other things, imposing sanctions in this situation would only serve to discourage parties from disclosing and addressing discovery errors in the future. So, Judge Peck, even though the defendant was timely with their notification and agreed to redepositions of 5 witnesses, shouldn't they have been ordered to reimburse fees and costs for those?
Maybe. I am not sure that all of the financial prejudice was cured here. But I think what the judge was doing is, saying, you did the right thing. You didn't play games. You didn't, as soon as you found out about it, you told the other side, you told the court, you fell on your sword, or at least fell on your vendor's sword, and you agreed to those depositions. Had they fought the depositions, it might well have been that the cost of motion practice should have been paid for by them. Query whether asking some additional questions at those depositions, is that really something that would not have been done the first time around? Is it repetitive, or would it have just added an hour to the prior depositions? So, and I also don't know. And one of the things when reading cases, unless you get really annoyed by something in the opinion or really intrigued, you don't quite know what the briefing was below. You know, was Fleur's request too piggy? And then the old doctrine about pigs get slaughtered or hogs get slaughtered, whatever that expression is. But if, you know, they were asking for too much, maybe that's why they got nothing. But I don't really disagree with what the judge did.
Okay. So, Mary, last month, of course, EDRM announced a new cross-platform email duplicate identification specification. So could that have helped in this case, and how can such an approach help parties generally in identifying dupes?
Good question. So here, the provider...
And good plug.
Yeah, thanks, Doug. Thank you on behalf of Beth Patterson and the team. So the provider here mistakenly deduplicated documents across the entire database instead of using the specific environment with documents to be produced. And so they excluded some documents from productions as duplicates. So our specification to the message ID hash to be able to identify duplicates would not stop that situation. It requires that there be oversight, and it will allow groupings of duplicates in the same way, you know, across a whole database if you want, across a case, across other cases, across media types, custodians. So there's a specific filter that's necessary inside a shared database environment for it to work for deduplication. And let's just say there should be consultation. There's considerations. We've got those considerations documented in the materials on our website. Craig Ball has written a white paper on it. And so used properly, it can be helpful in deduplicating properly. And used not properly, it would have a similar result here.
Certainly, but yeah, as many different sources we have these days, to have something that goes across the platforms is certainly a great thing to have. So kudos to EDRM and the team that put that spec together. So Tom, the reason for the vendor error was, as we talked about, documents were improperly identified as duplicates. So how can parties avoid a mistake like that, or their vendors avoid a mistake like that?
Well, I mean, that's a head scratcher to me. How do they improperly identify something as duplicates?
Right.
Usually it's the reverse, right? But anyway, two things I would say. First of all, what's your product? You know, what product are you using to do the deduping? And have you used it before and tested it and make sure that it's valid, which really feeds more into the more important thing, I think, which is the process. You know, as Mary just described, what's the process you're using to do this? And have you got, and that's the real strength, I think, to the project that EDRM is working on, is to give us a process that we can all look at and say, well, we did it all the same way, and we know that this works if you do it properly. But finally, you got to test it and make sure you did it properly. Maybe they had a great product and a great process, and they just didn't do it properly, like the prior case where they had a protocol, but they didn't follow it. So, you know, what sort of QC do you have? What sort of second pass of the deduping process do you have to make sure that you're getting the same results? And, you know, maybe a quick turn would have done that. Have you done some sort of QC sampling to see what sort of results you get? So I'd really take a long, hard look at the process and what you did and how you did it.
Yeah. It's a head scratcher to me too. And comment from the audience, processing costs pertaining to high deduplication errors. I mean, near 80,000 docs is a lot. And she felt that costs should be transferred to the infringer as it relates to their initial error. And certainly opposing counsel would likely have started their review before the dedupe issues were found. And dedupe processing is a standard and straightforward eDiscovery function. I certainly
should be.
Yeah, should be. So, yeah. But you know, it wasn't in this case apparently. But we must move on to the next one, so we'll do that. And this one's a first for us, a Section 1782 filing related to patent litigation in the UK and Germany over allegations that AES infringed Lufthansa's European patent for its electrical power supply device by marketing and selling its own system in Europe. The parties had a dispute over whether AES must provide Lufthansa with all the meeting protocol documentation in its possession responsive to all search terms from the parties' agreed upon search terms, or just the protocol documentation AES deemed relevant to the patent infringement proceedings, and whether AES must supplement the master list of parts previously produced to Lufthansa. Lufthansa indicated that the seemingly broad discovery was needed in large part because AES productions to date had been demonstrably incomplete. Washington District Judge Coinauer, and I looked up the pronunciation again, Tom, it's different parts of the country apparently, observed that given the purpose of discovery here is to support Lufthansa's efforts to prove up damages in the UK and German proceedings, it is in AES's interest to share less, not more, information with Lufthansa. He also mentioned in a footnote, this is borne out by AES's seemingly unnecessarily narrow interpretation of the subpoena in this matter and the court's prior order regarding production of the MPL, along with AES's dealings with the court on a prior Lufthansa discovery petition. Granting the motion to compel, the judge stated, based on the court's review of the parties' voluminous submissions on these issues, including briefing on the instant motion, supplemental briefing on the issue of the MPL, supporting declarations and exhibits, the court concludes that AES must produce the discovery Lufthansa currently seeks. However, he denied Lufthansa's motion for sanctions, stating, for a contempt finding, Lufthansa must show through clear and convincing evidence that AES violated the court's specific and definite order. Lufthansa cannot meet this standard. However, given the guidance now contained within this order, the court does not expect that AES could put forth a similar argument in defense of a future motion for contempt from Lufthansa, at least as it relates to this particular discovery addressed in this order. So, Mary, are you surprised that the judge required AES to produce all search term results for meeting protocol documentation without review, considering how unreliable search terms can be?
Well, I don't think it had to do with the reliability of the search terms. I think it had to do with what you had read a little bit earlier. The sentence that goes, this is borne out by AES's seemingly unnecessarily narrow interpretation of the subpoena in this matters. And then going on to say that there were prior dealings that left a bad taste. So I think this is one of those isn't it Rule 1.1, Judge Peck?
That's exactly right. AKA, do not piss off the judge.
Exactly.
Right. So, well, okay. So, and that, Tom, I was going to ask you, Judge Coinauer cited AES's dealings with the court as part of his consideration. If they hadn't been difficult before, do you think he still would have ruled this way and ordered them to produce search term results without reviewing first?
Well, I think his decision would have been this way only for one sentence that he had in the middle there, where he really kind of fell on his sword and said that that he, the court, in his, and I'm quoting now, his quote, prior order regarding the production of the MPL may not have been sufficiently clear to rise to the level warranting contempt here, end quote. And then he went on to say something along the lines of, but it's really clear now, so I better not hear this in the future. But I thought that was really interesting that, the party raised the suggestion in their briefing that his order was, if not vague, not super clear, and he agreed, and therefore denied the Lufthansa's request. So I thought that was an interesting take by Judge Coinauer.
And maybe that last sentence could be taken out. Don't piss off the judge anymore, maybe.
Exactly. Oh, he made it real clear that
right.
He was invoking 1.1 going
exactly.
forward.
Indeed. So one of the things interesting about this case, Judge Peck, is it stems from a Section 1782 filing. So what is a Section 1782 filing, and what should our audience know about it?
28 U.S. Code Section 1782 allows discovery, quote, for use in a proceeding in a foreign or, can't read my handwriting, foreign or international tribunal, close quote. So if a person or a company is located in a judicial district in the United States, a special proceeding, in essence, a case, can be brought to get that party to produce material to be used in a foreign court proceeding. That's very clear. The Supreme Court last term dealt with the question of what is a tribunal and found that private arbitrations are not tribunals within the scope of the act. So here, AES presumably is located in the Western District of Washington, and therefore Lufthansa could seek evidence from them for use in that foreign proceeding, regardless of whether it could have gotten that discovery in the foreign jurisdiction. So in the UK, quite possibly it could have. In Germany, where they don't have US-style discovery, it probably couldn't have. And so that's when parties bring these proceedings in the United States, often in the Southern District of New York or one of the California districts. And it's very useful, probably not utilized by foreign parties as much as they should.
Yeah. Certainly haven't seen too much of it up to this point. Question, I think he's asking, was the Lufthansa order specifically to produce without review, without a privilege screen, any protections? I didn't note any discussion of privilege review. Did any of you note that?
No.
No. I mean, I am not a big fan of it hit on the search terms, so produce it. Here, there was a reason for that. Generally, where that occurs, either the judge is just wrong or 1.1 was violated. And for those who might be new to these, things, before you're saying, where in the federal rules of civil procedure is 1.1? I don't see it. You don't see it, because that's my way of referring to the unwritten rule of don't annoy the judge.
Annoy?
Well, yeah, that's
in whatever word you want to use.
Well, very delicately put.
Yeah.
Yes, and indeed, we've seen that rule violated in many of our cases over the years we've been doing this.
Yep.
So we'll move on to the next one. Here's a case where a New York judge used a Texas law to make his ruling. How about that? In this case, the plaintiff served non-party Bajorquez law firm with a subpoena alleging that communications between one of the firm's lawyers and various municipal bond market participants spread misinformation about the plaintiff and the services it offered to potential borrowers, and were therefore relevant to its claim that the defendant organized a boycott of the plaintiff among those municipal bond market participants. In response, Bojorquez produced certain documents, but withheld approximately 170 responsive emails on the basis of attorney-client privilege. The plaintiff filed a motion in the Western District of Texas seeking to compel Bojorquez to produce the allegedly privileged documents. It argued that some of the documents in question had already been produced by the market participants over which Bojorquez claims privilege, thereby undermining the assertion of privilege. In October of last year, the court in the Western District of Texas transferred the motion to the Southern District of New York, finding that because the enforcement of the subpoena relates to the underlying action pending in the district, the interest of having a single court decide issues related to subpoenas for discovery in this case outweighs the party's interest in having the issue decided in Austin, which is where Bojorquez is located. The parties were directed to meet and confer for the purpose of identifying a sampling of documents to serve as exemplars for in-camera review, and counsel for Bojorquez was also directed to provide a supplemental response to explain their position with regard to privilege. New York Magistrate Judge James Cott began his analysis by stating the court applies Texas law to its privilege analysis. Here, the privilege claims are governed by Texas law because Texas is the state with the most significant relationship to the communications in question. He also noted, while Bajorquez argues at length that the subpoena is unduly burdensome, its objections are untimely. However, Judge Cott also stated, in instances where a party has failed to justify its assertion of privilege, a court can still review the documents in question. Of the 21 exemplar documents produced, Judge Cott found 9 documents to be privileged as asserted, but he found the rest not to be privileged, stating, any substantive information appears to be coming not from a lawyer or client, but from one of the third parties. It's not the presence of these third parties in and of itself that breaks the privilege, but the contents of the documents which do not appear to seek or provide legal advice. He also denied Bajorquez's remaining requests and ordered them to produce the exemplar documents and all documents matching those. So, Tom, are you surprised that Judge Cott decided to apply Texas rules to his decision since the case was transferred to him?
No, I mean, you said it in the slide. You pointed it out quite nicely. He actually began his analysis by saying, I'm applying Texas rules because those are Texas is the state with the most significant relationship to the communications in question. So I thought he laid out his reasoning right away so that everybody would understand why he was doing it.
Mm-hmm. Sure, makes sense. So Judge Peck, are you surprised that Judge Cott only directed the firm to produce the most exemplar documents, or even conducted an in-camera review in the first place, given that their objections were untimely?
Well, I think judges are particularly careful with respect to claims of privilege. If the objection had been the request was overly broad and you didn't follow the procedural rules, a judge might well say, too bad, learn the rules. But privilege is something that is supposed to be protected. So, I think it was eminently fair for Judge Cott, my former next door neighbor in the courthouse, to review on the merits, so to speak, of the privilege claim. 2 points I want to note. First, there is no right to an in-camera review. We've seen cases within the last year or two where judges have said, I'm not spending my time on an in-camera review, even of samples. You don't deserve it. You haven't made the appropriate approach. The other point is this might be a good, quick refresher on Rule 45 non-party subpoenas, which is to say that enforcement is in the court where the subpoena is to be complied with, Texas here. But if either the person being subpoenaed or the court finds that it makes sense to move the motion to where the case is pending, the court has the ability to do that. And that's what occurred here.
Yeah, certainly did. So Mary Judge Cott ordered Bajorquez to produce all documents matching exemplar documents. Aren't those documents that match the exemplar documents open to interpretation?
That's a really good question, Doug, because when I looked at it, and it's like matching exemplars. Okay, so matching can mean exact dupe, near dupe. You can do clustering. You can have a high threshold in your tar or your cal. There's many different ways to look at that. So yes, I think that's kind of a squishy order, and I think that many dollars per hour would be spent discussing it.
Sure. I'm hoping that maybe the meet and confer that happened before, they established some guidelines as to whether, in picking the 21 that said, okay, these also relate to these others. So if these are not privileged, then these others aren't either, or something like that. But that is one of the things that I was trying to think of. How are they defining matching here?
Exactly.
If you went back to the court having taken a too narrow view of what is a matching document, you are likely to incur the court's wrath. So that's something that the party claiming the privilege would have to think about before taking too expansive a view and being forced to defend that view in front of the judge.
Sure, that certainly makes sense. All right, so we'll move on to our next case. I think this case is somewhat of a matter of anything you can do, I can do better, or maybe perhaps worse. And this case was also suggested by Judge Peck. It related to the city of Seattle's alleged support and encouragement of the Capitol Hill occupied protest from June 8th to July 1st, 2020, and its impact on local property owners, businesses, and residents. Plaintiffs requested sanctions for the deletion of thousands of text messages from city-owned phones of city officials, including three pretty important custodians: the mayor, the police chief, and the fire chief. As stated by Washington District Judge Thomas Zille, looking at Mayor Durkin in particular, he noted that the various reasons stated for deleting her text messages, including dropping her city-owned iPhone 8 Plus into the water while she was visiting a beach, stopping iCloud synchronization, and setting all text messages stored in iCloud to be automatically deleted in 30 days, he indicated that those all strained credibility. Overall, there were 7 custodians for which litigation holds were issued late and for which messages were deleted and/or phones were reset. Now, of course, notably, the city also alleged that certain plaintiffs were also responsible for mobile device data spoliation through the deletion of text messages as well. Despite the fact that the city had created over 161,000 deleted text messages, Judge Zille stated the city, however, ignores that it has not recovered any deleted text messages exchanged directly between Mayor Durkin and Chief Best, Mayor Durkin and Chief Scoggins, or Chief Scoggins and Chief Best during the CHOP period. The parties do not dispute that these high-level officials communicated directly with each other via text message during the CHOP period. The court therefore concludes that a substantial number of the deleted text messages are lost and cannot be restored or replaced through additional discovery. Judge Zille also stated the city cannot reasonably dispute that significant evidence is missing in this action and can never be recovered. However, while finding that the city acted with the requisite intent to deprive within the meaning of Rule 37E2, Judge Zille chose to issue an adverse instruction at trial that the jury may presume that the city officials' text messages deleted after plaintiffs commenced this action were unfavorable to the city. And he also awarded attorneys' fees and costs, including expert-related costs, incurred as a result of the city's spoliation of evidence. Those fees and costs, which are not noted on the slide here, ultimately came to $600,000 as part of a $3.65 million settlement in the case. Judge Zille did also award sanctions for the defendant, allowing the defendant to present evidence of mobile device data spoliation by one plaintiff individual, which of course became moot when the settlement happened. So Judge Peck, if these devices had been BYOD devices instead of city-owned devices, would that have changed the possession, custody, and control of the devices and changed whether sanctions were applicable on the city?
Yes and no, or the old lawyers, it depends. Washington, Seattle, it's in the Ninth Circuit. So as we all know, of the circuit split, the Ninth Circuit employs the legal right test for possession, custody, or control, as compared with, for example, the Second Circuit and others that use the practical ability test. But it would have, pretty hard for the mayor, chief of police, and fire chief to say that whatever device they were using in this period was not governmental records. And it is quite likely that some government records law or something like that would have superseded the just possession, custody, or control tests. These were clearly messages in the course of business. the mayor at least would have to worry about running for election again. And, if playing games of, oh no, the city doesn't have the right to get these messages, etc., that won't look good when it's a centerpiece of the next candidate's, campaigning against the mayor, etc. But, I think it is incumbent from this and other cases we've looked at for companies to closely look at their BYOD policies and how that might impact future litigation.
Yeah, absolutely. It's a very interesting issue, and certainly a lot of considerations to it. So, Mary, obviously, sometimes we see cases where there's a de-emphasis on mobile device data. So, do you think any of the actions of the city officials can be attributed to a lack of understanding of the importance of text messages in eDiscovery, or do you agree, like Judge Zilli said, that this was a case where the city hid the ball?
Well, it's interesting because each one of these city officials, if they did hide the ball, they hid the ball in a different way. I mean, one dropped it in the water and stopped iCloud synchronization and actually set auto delete on during a legal hold. The other one was an exit interview fail, perhaps. Or some counseling before the exit interview because she returned her phone with no messages, deleted messages from her phone periodically, and then Chief Scoggins reset his phone in an Apple store after he allegedly forgot his numeric password. So each one had a different way to get rid of the messages, but they all got rid of the messages during a time period. And that certainly looks suspicious. And this is not Seattle's first rodeo on text messages. So I do think they knew about it.
Interesting. Yeah, I was not aware of other cases where this came up, but certainly, yes, they're either the unluckiest and the at least tech savvy people around, or there's something more to that, interestingly enough. So, Tom, one of the things, and I had a couple of comments on the blog post about it, do you think Judge Zilli went far enough with a may presume adverse inference sanction, given the extent of the ESI spoliated across multiple key custodians?
Well, you would have thought he might have gone further and invoked the Death Star sanction. But, I first of all, I find that, and Judge Peck may have some perspective on this, I find that judges tend to be reluctant to do that unless it's the most egregious, darkest Darth Vader ever destruction of property that's beyond any shadow of a reasonable doubt. But I also think that in this case, this was a hugely contentious social issue in Seattle. I don't know if people are outside of Seattle are aware of how big a deal this was. It was a group of citizens took over basically an area up at the top of Capitol Hill, which had centered in a number of other social upheavals over the years, and basically made it the People's Republic of Capitol Hill, or words to that effect. And so I wonder if Judge Zilli might also not have wanted to impose his interpretation of the impact of the data loss on this for that of, in essence, the community or the 12 representatives of the community on the jury, and felt that maybe that should be something that they should weigh in on. I don't know that that's in. There's certainly nothing in the decision that says that. But as I said, this was the impact of this case on the psyche of Seattle, which had always prided itself on being a very congenial, friendly, everybody gets along sort of town. This really was divisive in a way that nobody saw coming. So I wonder if that impacted his decision at all.
Perhaps so. Certainly, if this case doesn't illustrate the importance of discovery of mobile device data and preserving your text messages, I don't know what does. So, very interesting data, or very interesting case. I wish I had a bigger slide to cover all of the because it was a long case, but it was a good one, and certainly one that a lot of people took note of.
Real quickly, just in terms of an ineptitude, how did the city not institute litigation hold for a month?
Right.
Right. I mean, that's the looming question to me is, we asked whether these three individuals should have known. Well, they should have been told. And they weren't. That really begs an answer.
And what about sunshine laws?
Right.
If you're the young associate in the corporation counsel office or whatever is the name of their legal department, how are you going to feel knocking on the mayor's door and saying, Mayor, remember, you got to save everything. We sent you that memo, or we're going to send you a memo. I mean, there are certain realities of government in big cities that has to be considered here as well. Was Seattle horribly negligent in how they handled all of this? Yes. Was there possible malfeasance beyond negligence in how these officials handled things? Yes. But, I remember once in one of the judges' trainings where it was a question of, conducting settlement conferences and, what do you do when the settlement is with the city and you're not getting a high enough official? And the trainer was saying, well, then you just tell the mayor to show up for the settlement conference. And I leaned over to one of the other New York magistrate judges and said, yeah, who's calling Rudy, you or me? In those days?
Yeah, good point. Good point.
Yeah. Yeah, very good point. Certainly an interesting dynamic to a case like this one. So, yeah, a very interesting case. We could certainly spend more time on it, but we have one more. So let's get to that one.
All right.
And in our last case, which is a class action regarding claims of fraudulent misrepresentations or omissions concerning Home Advisor membership conditions and service requests, Special Master Moore R. Grossman noted that discovery was contentious and protracted in this matter, and this particular dispute, a motion for sanctions brought by the HA defendants, has a long and tortured history, which included filing of 9 briefings in support of the parties' positions over a nearly 1-year period. I think I understand who was tortured. What led to the motion for sanctions was the granting of the HA defendants' motion to compel certain additional discovery concerning plaintiffs' contacts with the FTC, which the HA defendants alleged were improper and in violation of the protective order. The HA defendants alleged that plaintiffs produced, belatedly and only under court order, nearly 100 documents responsive to defendants' RFPs about plaintiffs' communications with the FTC to assist the FTC in its efforts to prosecute Home Advisor, which was an impermissible second use of Home Advisor's highly confidential discovery material in violation of the protective order. When the email communications were discovered, the plaintiffs switched to phone communications with the FTC, which were discovered when the FTC produced several voicemails from them. In considering all the evidence, Special Master Grossman stated, plaintiffs nowhere explain their sudden shift from written, i.e. email communications with the FTC to exclusively telephone contacts once the HA defendants sought to obtain their unproduced communications and the documents shared with the FTC beginning in April 2021. Clearly, plaintiffs did not anticipate that the FTC would retain copies of the voicemail messages plaintiffs' counsel left for the FTC and would later produce them to the HA defendants, which left them dead to rights. She granted defendants' request for the relief of attorneys' fees and costs, stating, plaintiffs' counsel's responses to discovery were calculated to and did obfuscate and mislead, and their repeated misstatements did not meet the standard of candor, cooperation, and professionalism expected of experienced and talented counsel of this caliber. And she also granted defendants' request for plaintiffs to pay all the master's fees associated with drafting the memorandum opinion and order and any related fees she incurred in connection with her analysis and evaluation of plaintiff's significant misconduct, which came to over $50,000 just for that. I can imagine the attorney's fees and costs will be a lot higher than that. And it could have been worse if Special Master Grossman didn't deny the HA defendant's request for relief regarding conducting further discovery into plaintiffs' communications with the FTC, to hold plaintiffs into contempt, to order that plaintiffs pay a $100,000 sanction to the clerk of court, and to bar plaintiffs from citing or otherwise relying on FTC-related discovery that the HA defendants produced in the action. So, Mary, are you surprised that Special Master Grossman sanctioned plaintiffs' counsel, but not the plaintiffs themselves?
Well, Special Master Grossman, she's a groundbreaking special master. She left us some good clues here. In one area, she says the master advised the parties orally of her ruling before she issued it, and then she warned the plaintiffs' counsel that they were at risk of bearing the cost of further proceedings on these matters. So she gave them a warning. And Doug, as you had gone through the facts of the case, it was the counsel that called up the FTC and left the voicemail. It wasn't the actual plaintiffs that did it, and that was a bad move, very bad move. And I think they got caught.
Right. Certainly seems that way. So, Tom, as I noted, the sanctions could have been much worse. So, do you agree with the decision not to bar the plaintiffs from using any FTC-related discovery, given how deceptive they were during the process?
Well, I read that a little differently, Doug. In reading her order, well, first of all, I do have to say, before I even say that, I've got to commend the special master in this case for reviving the long forgotten common law precept of gobsmacking. Quite prominent in the Irish community, especially in the Northeast. So, kudos to her. But with regard to the request on the FTC delivery, she states that she denied the HA defendant's request for relief to bar the plaintiffs from, quote, citing or otherwise relying on any FTC-related discovery the defendants produced in this action, end quote. So I don't think it was everything. I think it's stuff that's already been, using another long-forgotten legal concept, the stuff. I think it was material that had been already produced, and she was, it's already in, so it's in. That's the way I read it. I'd be interested if anybody else has got a different interpretation.
Sure. I mean, I guess the question is, what can they do with it? So I guess I was wondering if you were surprised that they are still allowed to use it as the case progresses. So,
well, if the defendants had produced it, if it's material that the defendants had produced, I think you get into a kind of sticky area, don't you? If you say
sure.
Something that's already been produced in discovery, now you've got it, but you can't use it.
Right. Yeah, that's fair. Absolutely. By the way, I think Special Master Grossman said literally gobsmacked, which Craig Ball meant is somebody literally slapped her across the face, which is what gobsmacked is, I guess, originally intended to mean. So
yes, gob is an ancient Irish word for head or often mouth,
yes.
Used quite prominently, perhaps most famously by Victor McLaughlin in The Quiet Man, the John Ford movie about Ireland, where he's repeatedly said to people, "Shut your gob."
Leave it to an O'Connor to hone in on gobsmacked.
That's right.
Very, very, very good. So, Judge Peck, certainly the back and forth emotions regarding this issue stretched out over almost a year. So when can you say that enough is enough? And does a special master have to be more patient than a judge who may be concerned about keeping their docket moving?
Well, I think the special master is equally concerned about keeping the docket moving in the case to which they are appointed. I mean, Magistrate Judge Mix appointed Maura Grossman here because the parties were obviously being pains in the neck, and the judge didn't have time to do that and deal with the rest of her docket. But, there is always the need to give due process, to give fair consideration to the parties. And it may be a sort of downhill standard. The district judge can snap his or her fingers, boom, and, decide immediately. The magistrate judge has to be a little more patient because his or her decisions can be appealed to the district judge. And the special master is an appointee of of whoever appointed, in this case, the magistrate judge. So I think there is the, wanting to give the parties full consideration of their issues, etc. I don't think I would have had the patience to do this for as long as Maura did. Do remember that the parties are paying special masters usually by the hour, so it's perhaps not as painful as the judges who are paid their paltry judicial salary no matter how much time they have to spend with, stupid motions. I want to follow in the shout out before on another EDRM project and just note that EDRM has published a bench book guide to use of special masters. It is available on the EDRM website. I was involved with it. Maura Grossman was involved, as were others. And it is a great resource for lawyers and judges in deciding whether they should seek the appointment of a special master, whether one as patient as Maura was here, or one more impatient or less patient.
Sure. Certainly was very patient in this case. And there was a lot of back and forth. So we are past the hour. I'll move to the question slide. I see one additional question. A couple of cases back, what criteria did Judge Cott use to determine privilege based on the exemplars finally selected? As I recall, what he said was, in terms of the ones he chose that he determined were not privileged, he said it was the contents. It was the contents of the documents which do not appear to seek or provide legal advice. That seemed to be his determining factor to rule those not privileged. So I assume the others, he must have found some indication that there was some level of legal advice being sought or provided. Any other comments from any of you all on that one?
I mean, the only thing I would say, and it's not clear whether it applied in Judge Cott's decision or not, but the hardest issue in looking at is something privileged is the dual hat worn, particularly by in-house counsel. Is that counsel giving business advice, which is not privileged, or legal advice, which is privileged?
Yeah, that's certainly fair. Got a lot of great questions and comments this time. Thanks for all your participation. Our next case law webinar is Thursday, April 20th. And the number 3 there is significant, but you'll have to tune in next time to find out what's significant about it. So until then, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. So if you'll press on that paperclip on the right side of your console, you'll find ways to reach eDiscovery today to subscribe. You can check out Tom O'Connor's Spicy Techno Gumbo blog, learn more about how to engage with Judge Peck. And tomorrow, our next webinar is ChatGPT. Should eDiscovery lawyers be nervous? And also the spring eDiscovery Business Confidence Survey is there for you. You can download a certificate of attendance from the Counsel after the completion of the webinar. And we thank you, Doug, Tom O'Connor, Honorable Judge Peck, for the wonderful shout outs to the EDRM project team's work product and this insightful presentation. Our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, everyone.
Bye-bye, all.